Welcome to the Occupational Safety Leadership Podcast, episode number 106, with a returning guest, Ed Foulke. Now, Ed, today I actually printed off your everything, so it would be a lot easier and smoother. So, Ed is a partner with Fisher Phillips, former Assistant Secretary of Labor for OSHA, and former Chairman of the Occupational Safety and Review Commission. I might add, he's also the only person to hold both of those titles. So thank you so much, Ed, for joining me today.
Happy to do it.
And I think I'd like to talk about how that OSHA looks at things like penalties today. I sat down, I've tried to do the research, and it's almost like because it happens behind closed doors, I know what the statutes say and what's proposed, but I don't really understand how they kind of come with a final
Mhm.
conclusion.
Which most people do not. To be quite honest. It's kind of good that we're talking about this because uh, was it yesterday in the Federal Register, OSHA, actually it was Department of Labor, announced the annual increases in the penalty amounts. There was a change back in 2015, I believe it was, and I don't know. I think it was an amendment proposed in the budget bill, or a provision in the budget bill, which basically uh, said that you're going to, from now on, OSHA is going to, and MSHA and all the other administrative agencies that have penalties are going to be tied to the cost of living increases. So as the cost of living goes up, the penalty amounts will go up. So,
Oh, interesting.
so yeah, it's like a double whammy for employers. Whereas their 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 costs are going up, and now if they get inspected by OSHA, the penalty amounts are going to go up. So, starting on the 15th of this month, which is tomorrow. No, that's not tomorrow. It's Monday. My daughter's birthday. And anyway, so the penalty amounts for a serious violation are going to be now a minimum penalty is going to be $1,190 per violation, and the maximum penalty for a serious and repeat a serious violation is going to be $16,131. The minimum penalty, there is no minimum penalty for other than serious violation. Um, but the maximum penalty is the same as a serious violation, $16,131. Uh, the willful and repeat also changed as a result of this, uh, and now the willful. I'm trying to remember that. Yeah, and the repeat have a minimum penalty of $11,152, which is interesting because actually and I just think that's interesting that low, because now the maximum penalty for willful or repeat is 161,323. So we're talking a big bit of money, considering before 2015 the maximum penalty had been set in the act itself at $70,000 and hadn't changed in 25, 30 years. That's kind of funny. So now it keeps going up every year. So, and if you violate the posting, if you don't post like you're supposed to, the citations or the settlement agreement, whatever, now you could be looking at a penalty of 16,131, and also failure to debate. Now the failure to debate could get kind of expensive because the penalty amount for failure to abate is 16,131 per day.
Wow.
Uh, so it can get up. Usually they limit that to 30 days. Is generally the OSHA won't go beyond that. But then again, 30 days times 16,000. So let's see, 6 years, 3 6 years, 18, 3 1s, 3 4. So you're over $400,000
Wow.
for failure to abate. Now, So that's the new changes that just kicked in. Like I say, were published yesterday and go on into effect on the 15th. So now, kind of going back to what you originally asked about, how does OSHA calculate that? Uh, they do have some guidelines or guidance that they have in their field operation manual, and that goes into a lot of detail. We're not going to be able to get into the type of detail that it goes into there, but it spells out pretty much what OSHA, when they're deciding on the penalty amounts, how it has to be calculated. And so, if you're looking on chapter 6 of the field operations manual, if you go on OSHA website and just put in the question box FOM for field operations manual and click on that, you'll be pulled up. There'll be a list of them. You need to look at the most recent one, which I think is 2020 was the most recent one. There's some of the old ones are still listed there, but 2020 I believe is the current one to show. And this is the field operations manual goes into everything with respect to inspections and how they're going to be handled and all these other things. So they do put a lot of information in there on that. But on chapter 16, dealing with penalties and debt collection, is really kind of start off by talking about this. And basically how it starts out is you start out with the maximum penalty. When you get, if once OSHA decides, and there's a lot of analysis even before that, when OSHA decides whether or not they're going to issue a citation, they have to go through all the hoops as to, can they meet their burden of proof? Can they show that there's an applicable standard, assuming they're not going to cite the general duty clause? Is there an applicable standard? Does it apply to this particular situation? Can we show that the employer knew or with the exercise of reasonable diligence could have known of this violation and just failed to do anything? So that's kind of the test that OSHA has to meet with respect to issuing a citation. So once they decide that they're going to issue a citation under a standard, not the general duty clause, because the analysis is a little bit different on general duty clause, then they go and pick out what do they think? First of all, what is the classification here? What should it be classified as? And they kind of look at a lot of things. They look to the gravity of the violation, the size of the employer business, the good faith efforts, and the company's previous history of violations. And that's kind of where they start with respect to how they're going to classify this, either other than serious, willful, or repeat. Now the repeat, obviously, you have to have a standard that applies there that has been cited in the past. Or it doesn't have to be identical, but for the most part, it is when they do those things. So on a repeat, they'll look to see what was your previous history on citation history. What citations did you have in the past, and were they affirmed? It has to be a final rule on the standard that was applied for a repeat violation. So if you get cited at a company say you get cited, say you have multiple facilities, and you got a citation going on you've had one case where you were cited for, let's just say, guarding. That's an easy one to think about. And the guarding, and you ended up not contesting that one, and it became a final rule. You paid the penalty, and got the final. It becomes a final rule. So now at another facility, or it could be the same facility technically, but you have if it's a final rule, then you can get cited for a repeat violation if it was a guarding standard or something similar to guarding. But mostly, like I say, OSHA for the most part will do that. We'll look and try to cite whatever was cited previously, because it makes their life a little bit easier. Now, the one thing, if you haven't had a final rule on the first plant and you decide to contest the citation, then instead of settling, now that's an open citation. it has to be a final. You have to have You have to have a citation that was and as the specific standard has to be finalized. In other words, a final order of the commission, and that occurs one of two ways. First of all, either you settle the case and if you, assuming you can contest it, but even if you settle it before you contest, you still that becomes a final order. And so OSHA could use that as a basis for a repeat violation. If, however, if you got the citation, you say no, we didn't do it, we didn't violate that standard, and contest it, and it hasn't been finalized. In other words, you haven't had a hearing, or it's being contested up to the review commission or court of appeals, whichever, whatever. Then that cannot be used as a basis for a repeat violation. They have to have a final order of the review commission in order to be able to cite the next one as a repeat. So we need to remember that because that is important. There are a couple other things that you want to know about on repeats. OSHA can only look back 5 years. And there's case law, though. It says OSHA could look back 20 years if they wanted to. But OSHA is taking the position, and that's what's in the field operations manual, is that they will look back 5 years on a previous citation for a repeat violation. So if once the 5 years have passed, OSHA will not try to use that as the basis for a repeat violation. And then when you see a repeat violation, it's going to say in the citation itself, it's actually going to cite that this standard was cited in this inspection and it became a final rule on this date, and as part of the information they're providing in the citation itself for a repeat violation. So you got 5 years if in the Fed system, let's put it that way. The state plan states some of them are a little bit different, but some actually, I think it's California. I'm trying to remember. I think it's California. They don't care how long ago it occurred, so as long as it occurred now. Thing about state plans, this is the other thing you need to be understanding, is that citation for a repeat violation. I just lost my train of thought here. What was it there? You have the 5 years. If the citation has to be in a if OSHA, if it's federal OSHA trying to issue a repeat violation, the citation wherever it occurred, previous citation that they're trying to base on, that has to be in a federal state. It can't be in a state plan state. So and so you have this other situation, and for state plans, then you can only get a repeat violation from a state plan if the citation, the previous citation, which is now final, was actually issued by that state. So you're unlimited to on the repeat violations. You're limited very much to in state plans only to whatever they had cited before. So so those are kind of two things that you need to understand about that. So okay, so when like I said before, we had the gravity, size, good faith, and history. These are also used to determine how much, if they're going to have any type of reduction, because in the penalty amount, because what they do is they start out with the maximum penalty, and then they take deductions from that to get down to whatever number they get down to. So they've had to think that out fairly seriously there. So, but they're going to look to see what is the severity of the injury or illness that could occur from the alleged violation. So they're not going to look and say, well, what actually happened? They're going to say, what could have been the severity of the if from this violation, if an accident actually occurred as a result of that violation. So that's going to also, and once again, that's going to determine, is this a repeat violation? Is this a serious repeat or not? So they're going to be looking at those type of things. So but clearly that's going to be, they're looking at the severity, and then they also look at the probability that the injury and illness could have occurred. So that's how they basically figure out gravity out, on this, is they look at the severity of the potential violation to cause an injury or illness, and then what is the probability that the injury and illness could occur. So though they don't have to have occurred either one, they didn't have to have an injury, they didn't have to actually have an accident. So but they still use that figures. So if somebody falls 20 feet off a scaffold and doesn't, luckily they bounced on a piece of plywood and it kind of almost to a certain degree breaks their fall, but it causes them, they don't have any serious injuries. Well, but OSHA is going to look at that and say, well, it still could have had a serious injury here because of that. So that's the kind of we're looking at there. So, and then they also are going to look at, with respect to severity, they're going to look at, is it high severity? I actually have these three categories: the high severity, medium severity, low severity. And if it's a low severity and the probability is low, then they may not issue a serious violation. It may be another than serious. It's just really kind of, so you really don't know. You have to look at it. But, of course, with respect to general duty clause violations, they look, because the definition of definition of general duty clause is that that is a serious violation, a serious hazard. And so they can't really go to look to the other than serious category for that particular, if there's going to be a general duty clause, if they don't have a standard that's applicable to this particular thing. So and then let's see, of course, if they have, as I mentioned before, if it for willful and repeat, then they got the maximum penalty, but they also have a minimum penalty. So if you're a small employer and had all these other factors, the size, good faith, no history, and let me put it this way: you don't get any deductions on history if you've not been inspected before. They have to go look at. You have to, in order to get that. Now, you do get good faith and you do get size deduction, but history, if you've never had an OSHA inspection, or then OSHA is not going to look at that category for any type of reduction in the penalty amount. So you have that, and like I said, we talked about the determine the probability. Is it great? And that, as we had the high, low, medium for severity, on probability we have greater probability of an accident occurring versus a low probability, a lesser, they call it lesser probability of an accident occurring and somebody getting injured. And then how they determine that probability, they're going to look at what's the number of employees that are exposed. That's why you notice in an OSHA inspection, at the beginning of the inspection, they're going to ask you, how many employees do you work here? And they'll ask you also, how many employees work in this area? So like that way they can be, once again, it's going to determine the probability. So the higher number of employees you have exposed, the higher the probability that the accident is going to occur or could occur. And so that's going to give you a higher probability, which means the penalty amount is going to be greater than if it wasn't the opposite there. So they're going to look at the frequency and duration of employee exposure. And if you ever get, if you're handling an OSHA inspection, I do a lot of inspection, obviously. If you can test the citations, then, and you move forward, contestant, and you file a notice of contest, and OSHA issues a complaint, employer files an answer to the complaint. And normally what we do, well, not normally, all the time, whenever we get the complaint and we file the answer, we will also file at the same time interrogatories and requests to produce. And part of the request to produce will be requesting a copy of the OSHA inspection file, because there's a lot of information in that file that's going to help you. And it kind of goes to this thing. Part of it goes to this because they're actually part of the forms that are in there they actually have forms that they use when they're calculating penalties. So they're going to list how is this, what was the severity, what they decided what the severity number was, what was the probability number, how was it greater or lesser. So that's how they kind of look at that. So and then they're going to have on there the number of employees, the number of employees that are approximately to the hazardous condition, have proximity to the condition. So that's a so they're going to take that into play. Are they using appropriate personal protective equipment? All these different things. What type of training they've done? So the probabilities kind of factors in there once again. But so then they get this gravity-based penalty amount, and that's kind of when they start doing all the reductions based on the thing. So, but so when they're figuring out this gravity-based penalty, they're going to look at the severity and then look at the probability, and then that's going to determine if you have what type of gravity is this citation? What's the gravity of this violation? So if you have high severity and greater probability, your gravity is going to be high. Now, if you have medium severity but greater probability, you're going to be moderate gravity. Same thing with low severity, greater probability, same thing. You're going to have this high thing. So you're going to be moderate. And of course, if you have high severity but lesser probability, that's going to be kind of in the middle for the penalty amount. Medium severity, lesser probability. Once again, moderate, low, or moderate in the middle. And then if you have low severity and low probability, then the gravity is going to be based on it's going to be low, and that's going to reduce the amount of calculation, or the amount that the penalty is going to be calculated on. So that. But then again, of course, you also have what they call egregious cases, and that's where OSHA feels like the employer just really didn't care about that, and there's a bunch of violations egregious. Because normally, when they calculate this thing, they will, if you have, and once again, the question about number of employees exposed and stuff like that. As a general rule, they will only issue, even if you got 5 people or 10 people exposed here, if they don't think if they consider it to be moderate gravity or whatever, or that the employer was trying to do the right thing, then they're just going to group those together, all those people, all the violations of done by the thing. So, and this is where this is called the violation by violation approach to the penalty amount. This was done with Petridge Farm back in the 90s. I guess it must have been 90, maybe earlier than that. But it's Petridge Farm was the first case that they used this, what they call egregious. They call it egregious because they feel like the employer is not caring, and you got all these different violations of the same standard. Now, the Petridge Farm case, the egregious was failure to it was a record keeping case where they weren't putting all the people on the logs that should have been on the logs.
Mm-hmm.
And they thought it was so egregious, what they call it, they do it egregious, it's just the word they use. It was so egregious that then they decided they weren't going to group them all together into one citation and one penalty. So what they did was they cited every employee that was not on the log as a violation of the standard. And I think there was like, I don't know, 100 people, 100 entries that weren't put on the log. And so back then, I don't know how many it was. Probably was less than 100. But anyway, what it was it's the first time that OSHA ever issued $1 million penalty, because it was a willful egregious, and so they were every person that wasn't on the log that was supposed to be on the log, was a separate violation, and probably the full penalty. And back then, the full penalty was $70,000, but it got over $1 million for the very first time when it's good. So this is called the egregious penalty, and need to be watch out for that, because it can be egregious or violation, like violation by violation penalty. This has to do with civil cases, and they actually have some a directive on how to handle cases that propose a violation by violation, because they have to meet the requirements, certain requirements to be able to do it. And like I said, that's kind of the idea as combining or grouping. Normally, with respect to the penalty amount too, with respect to grouping, now you could have several different violations. And you're going to see, and you probably may have seen this already, where they it'll be a violation, and it'll be item citation one, item, if it's a serious, it'll be usually citation, it's usually citation one. And the repeats and willfuls are twos, threes. But anyway, so you'll see it listed there, citation one, item 1A, and then 1B, but it's all one penalty.
Mm-hmm.
There's no listed penalty on B and C and D and E and F, because they've grouped them all together into one citation. Now they're spelling out the citations, and so that they can show that, but they're not grouping. They're grouping them, and they're not issuing us, and they're issuing a separate penalty instead of breaking them out into individual citations with individual penalty amounts. And that's they have to look at those things. Now, normally on grouping, if you see a citation, they only have one penalty, but there's 2 or 3 citations, and they got the item 1, item 2, item 3. That means that they didn't think it was appropriate to group. But secondly, normally how they determine if there's going to be grouped or not, they look to see, is the abatement method for that violation the same as the abatement method for the next violation. And if it is, if the abatement is the same thing, then they normally group them together as one citation, but they still break it out as individual items. And so that's kind of how they figure out that particular part on that. But they look and see, because, and it's a defense. If you think you can show, to the violation, if you can show that the abatement is the same, to do it here, here's what we're abating here for citation 1, item 1, and here's what we're doing, the exact same abatement for citation 1, item 2, then our argument, the legal argument, is it should be grouped together because the abatement's the same.
Mm-hmm.
So they have that. That's how I do it. So a whole series of things that they look at when they're doing that too. So, as I mentioned before, there's other categories that the penalty adjustment factors. You get a 10% adjustment or reduction in the penalty given if you've been inspected but you've not had any citations issued, then you can get a 10% reduction off the maximum penalty. With respect to good faith efforts, and that's why, in a way, see, the 10% is history, and then the 25% is for good faith. And how do you get good faith? Well, if OSHA, the inspector, feels like you tried to cooperate during the inspection, you corrected things quickly, all those are that's considered good faith. And that's a 25% reduction in the penalty. So that kind of floats there, that they can figure out, well, it was some good faith, but not a lot. So we're only going to give them 15% reduction as opposed to 25% reduction. So you have that. And then you have up to a maximum 70% reduction based on the size of the employer and the number of employees. And that's why they ask you during the inspection, right at the beginning of the inspection, how many employees do you have? Because they're going to be doing that. And, once again, you get the 10% reduction for history, you have to have a final order by the commission. So it's all completed. So, And then, of course, for good faith reduction, you can't have a reduction if it's a high gravity serious violation, or a willful violation or a repeat violation, or a failure to abate. They're not going to. That's just things they're not going to do. And if you don't have any safety, you don't have a safety health management system, or there's major deficiencies in the program, you're not going to get a good faith reduction. So, but like I said, you can get up to a 25% reduction from the maximum penalty. So, and they do this one at a time. So they go to one, and then they do the next, and then the next. So you can almost get down to zero. Um, you know, if you're doing it, if depending on how they calculate it there. So, but usually if you have 1 to 10 employees, they'll give a 70% reduction in the
Okay.
penalty amount. 11 to 25 will give you a 60% reduction. 26 to 100, 30% reduction, and 101 employees to 250 gives you a 10% reduction. And if you're over 251 employees, you don't get any reduction for size. And they do have what they call a quick fix for penalty reduction if you abate what they consider the safety hazard or violation, if you quickly abate it. So, and that's why I always tell my clients, I mean, we got to be looking constantly during the inspection. I try to encourage them to make sure that they get me on board early on, because we can try to avoid a lot of stuff if we can. There's a lot of stuff, particularly in the penalty amounts. If you get the right stuff in front of them, you get that penalty amount reduced. Of course, they might want to keep it up because that way they can use that as a basis for trying to settle the case, or from OSHA standpoint. But if you get a quick fix, what they call the quick fix, then you can get some reducing the penalty amount also. So I think that's up to 15% is one of the amount that they can do there. So, but once again, there's some exceptions, and that's all spelled out, like I said before, in the field operations manual, so the FOM. So, I don't think is there anything else there that we have missed. Oh, one of the things is, sometimes I try to get this, and OSHA doesn't like doing it. There is a what they call an oh no, I had it on the tip of my tongue and now it disappeared. Kind of get bad when you get old. They do have what they call a de minimis citation. Well, it's not even a citation. If you can get something classified as de minimis, which means that it has no bearing on safety whatsoever, then normally OSHA won't even issue a citation. So that's another thing you can always try to argue, if you really think this is really a real stretch on a violation here, nobody could have gotten hurt or anything else like that, then you might try to push to say this is a de minimis and it should be withdrawn. Or if it's classified as de minimis, it's like I say, it's like it never happened in a way. Mm-hmm. So that's kind of the other thing that you want to be looking for. Trying to think what else. And like the field operations manual has all these other things that talk about that. They list, how many, if it's a willful violation, they have the different chart now for the number, what percentage reduction you're going to get. So, that's part of what you need to be looking at when you're doing those things. So, anyway, I think that's about it. Unless you have some questions on something, or?
Nope, everything was fantastic, Ed. So this half an hour has just flown by. Thank you so much. I'd like to have you back to really talk about contesting. So and not just the issues, how can I say it? And not just the things that we kind of think about it as like the really obvious things, but to talk about things like anything that the contributing factors. Just to kind of help to answer a couple of those questions. And so, love to have you back for
All right, well, let me
part
know.
3. Awesome,
yep.
Good. So, how can the folks connect and find you out there?
Well, I'm obviously, you mentioned earlier, I'm a partner with Fisher Phillips. My email address is efolke, so it's EFOULKE at Fisher Phillips, FISHERPHILLIPS.com. So that's my my email address. I always answer all the emails that I get. I get a lot of emails from people asking questions, and so I like to try to help people out. The other way is my cell phone number, which is 864-525-9669. I give all my clients my cell phone number because the type of work I do, unfortunately, bad things happen at night and on weekends.
Yep,
And
yep,
so
exactly.
they have to have that. They need to get a hold of me quickly, um, because particularly on a serious injury, multiple injuries, a fatality, um, you got to get on top of it quick, and it's very hard sometimes to do that.
Hmm.
And I prefer to be involved up front because that way I can avoid my clients shooting themselves in the foot, which unfortunately happens a lot.
Hmm.
There's employers out there that think that if they tell OSHA everything they know and give them every document they have, that somehow that's going to make things okay. And it's not. It's going to make it worse. And especially if you got a fatality, you can't screw around with those things nowadays. Well, you can't screw around with it normally, but now in this administration, they're always looking at a fatality to see if they can do a criminal referral,
Yep,
and
yep.
you have to get on top of that quickly. I mean, I have we actually have another lawyer in our Nashville office. She was a federal attorney, U.S. attorney. So she's done a lot of criminal cases before, and so now she's in our OSHA practice group. And so we have people that we can bring in. I've had